is all right, and let me just say that the second hour is being recorded, and now we posted on the section's website. So the second hour, in Atlanta, ALTA stands for Atlanta Lawn Tennis Association, but for the closing world, we all know what ALTA is. And so there were some new forms and policies that came out last year. And so we reached out to ALTA to ask for someone who could speak on the changes, additions or deletions, or just changes about the forms. And they sent us, helped us connect with two attorneys who were on the ALTA Forms Committee. That's Jonathan Anderson and Tucker DeLong, who both actually work for Connecticut Attorneys Title Insurance Company. And my computer just went to sleep. All right, I'm sorry about that. Hopefully you can still hear me. I'll make this brief so I can figure out my IT issues, but Jonathan Anderson is a vice president and chief underwriting counsel at CADIC. He's a member of the Forms Committee of the ALTA, as well as a member of the Real Property section of the Connecticut State Bar. He's a graduate of Connecticut College, Quinnipiac University School of Law, and the University of Connecticut School of Business. He has worked with Tucker DeLong with the presenting this material, and they'll do this together coming up. And Tucker serves as Associate Massachusetts State Counsel for CADIC. He's a member of the Title Standards and Forms Committee of the Massachusetts Role of the State Bar Association. In the interest, since I'm having some IT issues, let me just say that he is a graduate of Vanderbilt University. So he is spent some time down here near Georgia. So I will turn it over to you two. Go ahead and take it away.
Yes. Now, I'm sharing my screen, and I just need to get the ball rolling here. Is Lane on?
At the top, do you see?
Yes, I'm here, John.
Okay, I'm just looking at the top controls here. I just want to know which one to hit.
Okay, we're seeing the presentation. You'll just use your arrow keys or your space bar to advance through the slides.
And when I try to do that, it's not moving. That's the only thing that I'm concerned with.
Okay, then let's see if Tucker can pull his up.
Yep. Let me, John, if you want to stop sharing your screen,
okay.
I will.
Yep.
Let's see here. Everybody seeing this?
That looks good.
Yep.
Just pop it in presentation mode.
Yep. And there we go. Are we good?
Yes.
Yep.
All right.
Yep, very good. All right, so thank you, Tucker. I guess you'll be controlling. Thank you, folks. And obviously, I'm not the tech savvy one in this group, but my name's John Anderson, and welcome to our program, What You Need to Know About the 2021 ALTA Forms. Our speakers today are myself, John Anderson, and Tucker DeLong, and you did see our pictures back there a moment ago, and obviously—
I moved on quickly from that slide.
Obviously, we're much better looking in person than our pictures would indicate. So I do want to, before we move on, I did want to thank Chad for that great presentation, and of course, thank the government agencies that protect us every day. We're going to try to talk about something a little bit lighter here in terms of these forms, and we thought it would be interesting to talk first about the process of creating the forms and how they get adopted, who does that work, and also why are the policies being revised now? And the most important part of the program would be what changes there are in these policy forms. And we're going to be concentrating on the standard policy forms because those are the forms where most of the changes have taken place. And you will see, or we'll have a few moments to talk about some of the changes in the other forms. And a lot of those other changes were made to be consistent with the changes in the basic standard loan and owner policy forms. And finally, we'll talk a little bit about how you can prepare, although obviously if you're attending this program, you're taking that first step. So we'll go on to the next slide and mention this process. So it does begin with an idea, and oftentimes that idea comes from members of the forms committee, and those ideas can be received from the company they work for, or their customers, their agents, including lenders, and also GSEs, professional organizations. But these ideas are then brought to the forms committee. And if the forms committee considers a need to develop a new form or revise an existing form, a subcommittee of the forms committee will be created. And the charge of that particular subcommittee is to draft that particular form. And that's a process that can take months or even years, but it may depend on whether it's endorsement or a set of policies that are being drafted here. And in any case, once that process is done and the form is ready for presentation to the full committee, it goes before the full committee and then is subjected to yet another round of review and very intensive vetting that is really the hallmark of the full committee. And once that process is done and the committee feels that the form is in relatively final form, it is then adopted by the committee and recommended for adoption by the American Land Title Association, sent over to the ALTA Board of Governors. And after that process, which can be lengthy, and the receipt of that recommendation by the ALTA Board of Governors, that formal adoption by the ALTA is almost always guaranteed. Then the form is put out there for public comment. Comments are received and sent back to the forms committee, and the form committee considers, I would say, practically every single one of those comments. And in some cases, some of those comments end up with an effect on the content of that particular form. That is, changes may be made as a reaction to or because of some of the comments that have been received. And then there is a final publication of that form, and that form is given an effective date, and then it is up to the individual companies to decide whether or not to adopt that form. So then we look into or just confirm who does most of the work here, and I think the primary place where the forms are developed and vetted and revised is in the ALTA Forms Committee. And that's made up of over 60 members, which is a lot larger than it was when I first joined, and that represents over 20 title insurers. But we also mentioned the ALTA Board of Governors. We also do get some help from other sections of the American Land Title Association, including the underwriter section and the executive committee. And as I mentioned, we do get comments and suggestions from industry partners and customers, including the American College of Real Estate Lawyers and the GSEs such as Fannie Mae and Freddie Mac. So why revise the 2006 policies? Well, the last time there was that significant revision to the policies was over 15 years ago. And in the meantime, there's been plenty of new laws that have passed, new regulations, and lots of court decisions. There's been a new Consumer Financial Protection Bureau created in that period of time. And lots of states have authorized remote online notarization. And you'll see that that's reflected in the 21 forms. One of the cases that has come down in that interim period is a recent case of McGirt versus Oklahoma, which was a Supreme Court case that came out in 2020. Because of the issue raised in that particular case, which we'll discuss in a moment, there was an operative law subcommittee created within the Forms Committee that looked into this, drafted some recommendations, and fairly elegant fix, simple and elegant fix was made to the 21 policies to address the issue raised in McGirt. There's also been a lot of legislative and judicial attention paid to discriminatory covenants over the years. There was a subcommittee, the existing Forms Subcommittee, that looked into making some recommendations to revise the language that was first used and first appeared in the 2016 ALTA commitment. But that has been revised pursuant to these recommendations. And you'll see that language now in the 2021 policy forms, as well as the 21 commitment and a lot of the other policy forms that have been revised in 21 besides the basic policies. So in McGirt, the Supreme Court held that the state of Oklahoma lacked jurisdiction to prosecute a Native American who had allegedly committed a very serious crime within the boundaries of a reservation, saying that or finding that a federal statute controlled who had jurisdiction. And in that case, that federal statute gave concurrent jurisdiction to the tribe and the federal government, but not the state. The issue that this raised was with regard to the applicable law or the law to apply in a case involving a claim where the rights and liabilities of the parties have to be determined. Normally, that default would be the law of the state where the land is located. But because of the holding in McGirt, there was a possibility, or clearly there was a situation where in some cases the law of the state would not or could not apply. So the, again, the kind of simple and elegant fix that was incorporated into the choice of law provision of the new 21 policy forms was the statement that normally state law, that is the law of the state where land was located, would apply unless federal law controlled. And in that case, we would apply federal law. Okay, we can move on to the next slide there that talks about where the changes are made in the policies, and well, basically everywhere. There's changes in the covered risks, the exclusions, the schedules, and the conditions, including some new and revised definitions that we'll talk about, both of us will talk about actually. So let's get started. The first place that we see the change in both policy jackets, that is the owner policy jacket and the loan policy jacket, is in some introductory language right at the beginning that incorporates the coverage provided by the policy authentication endorsement. This was an endorsement that was created a while ago in recognition of the fact that more and more transactions were occurring, more and more policies were being issued electronically. After the endorsement was created, some of us on the Forms Committee thought that it would be a good idea to simply incorporate that coverage into any new policy form. And this is the solution that the full committee came up with. It's a great place to have this right at the beginning, stating that as long as the insurer issues the policy with a policy number and an effective date, the policy is going to be valid even if it was issued electronically or lacked signatures. So that's a great new addition. And as we will throughout the program, we're going to summarize the change that's made and then include an exact a copy of the sections of the policies or policy where that change takes place, so that you can see that language. Here you see that introductory language talking about that particular coverage that's incorporated here. So let's get into the covered risks now, and we're not going to talk about every single covered risk in the policy. We're going to be concentrating on those that have significant changes. So there's a change to covered risk 2, and you'll know that covered risk 2 is in both the loan policy and the owner policy. And just like in the existing form, the 21 policy insures against loss or damage resulting from any defect, lien, or encumbrance on the title. And then again, like the existing form, it offers examples of some of the risks or some of the situations where there is coverage resulting from, for example, in this case, updated examples saying that there's coverage resulting from for example, a deed not being properly executed or notarized, including by remote online notarization, or loss resulting from the repudiation of an electronic signature by someone who signed that document electronically, claiming that that electronic signature is invalid under applicable law. There's also an upgrade to the coverage provided by Covered Risk 2C, that's the survey coverage provision, to add a boundary line overlap as another one of the matters that's covered if it would otherwise show up on a complete survey of the land. And again, here's the provision, Covered Risk 2, that is in both the owner policy and the loan policy. Now, both the loan policy and the owner policy also have covered risk 5, 6, and 7. And just like in the existing forms, there's coverage for loss resulting from the violation or enforcement of, in the case of covered risk 5, governmental regulations. In the case of covered risk 6, the exercise of other governmental powers, and we'll mention the change in the language of covered risk 6 in a moment, or loss resulting from the exercise of the power of eminent domain. Now, the existing policy says that there was coverage when there was a notice of violation or enforcement or a notice of exercise recorded, but there was no definition of what that meant. Now in the 2021 form, there is coverage under these 3 provisions, under these 3 covered risks, to the extent that the violation, enforcement, or exercise is described in an enforcement notice. And an enforcement notice is a new defined term, which together with the revision of the defined term public records, significantly clarifies the type of notice that's going to trigger coverage under these 3 provisions. And a 4th provision as well that we'll get into in a moment, and where that notice needs to be recorded. So if we look at the language here, we can see covered risk 5 looks very similar to the way it does under the existing policy form. Covered risk 6, however, does have some changed language. In the existing form, it's simply referred to the enforcement of any governmental police power not otherwise referred to in covered risk 5. But here it talks about the enforcement of a governmental forfeiture, police, regulatory, or national security power. So that is new language. And then we have covered risk 7, which again, looks very similar to covered risk 7 in the existing policy. We also have on this slide the definition of enforcement notice. Romanets 1 or 2 address the enforcement of a governmental regulation or the exercise of some other governmental power, including the power of eminent domain. But Romanet 3 is new in terms of stating that an enforcement notice can also include a document that asserts a right to enforce a PACA PASA trust. So that leads to the question of what is that all about? And that's there because both policies have a new covered risk 8 that insures against the enforcement of a PACA PASA trust to the extent of the enforcement described in an enforcement notice. Now, PACA stands for the Perishable Agricultural Commodities Act. PASA stands for the Packers and Stockyards Act, and both of those laws establish a trust in favor of, in the case of PACA, unpaid suppliers and sellers of produce, and in the case of PASA, an unpaid packer of livestock. And those trusts are imposed against the assets of the recipient of that produce or the recipient of that livestock who has not paid the supplier or the seller or the packer. And the interesting thing about these trusts is that they can exist in unrecorded form. Remember, this particular covered risk insures against the enforcement to the extent that it's described in a recorded enforcement notice. And here we have the provisions. Covered risk 8 appears in both the loan and owner policy and the definition of PACA-PASA trust. Okay. So now we'll move on to a couple of provisions that are specific to the loan policy, including covered risk 9. Again, there's also a covered risk 9 in the existing policy form. And just like the existing covered risk, this updated covered risk in the 2021 loan policy insures against loss or damage to the extent that the invalidity or unenforceability of the mortgage is caused by a defect in the title, and then gives examples of a number of things, just like covered risk 2, that will be covered, including the insured mortgage not being properly executed or notarized. It's like covered risk 2, including by remote online notarization, or the insured mortgage being invalid or unenforceable because somebody who signed that mortgage electronically repudiates that electronic signature because the signature supposedly or allegedly is not valid under applicable law. Now we can move on to covered risk 10, which in the existing policy insures against a lack of priority of the insured mortgage, and does the same thing here, but now it explicitly insures against the lack of priority or against loss resulting from the lack of priority as to specific components of the indebtedness. And of course, some of these are not surprising, such as principal and interest, but there are some new ones that are more delineated, such as amounts advanced for insurance premiums by the insured lender, or amounts advanced by the insured lender before the acquisition of the title to protect the priority of the lien, including advances to pay taxes and assessments assessed by a municipality, for example, or even periodic assessments by a homeowners association. And this is an example of one of those covered risks where the revision is the direct result of comments received from a customer group, in this case, the GSEs, such as Fannie Mae and Freddie Mac. In fact, the full committee met with both Fannie Mae and Freddie Mac in Washington, D.C. during one of its meetings just a few years ago to discuss some of the issues raised here. Here we see where that exact language is. And now moving on to covered risk 13 and covered risk 9, covered risk 13 in the loan policy, covered risk 9 in the owner policy. This is the covered risk that addresses or provides coverage against certain risks posed by creditors' rights. And the existing policy form has two subsections. And in the first subsection, there's a protection against loss resulting from the avoidance of the insured mortgage or resulting from a court order providing for an alternative remedy as a result of a defect in title being created by a transaction occurring prior to the one that creates the insured interest. So some conveyance back in the chain is defective because, for example, that transfer constitutes a fraudulent transfer or fraudulent conveyance. So there's coverage there and similar coverage here in this one, although it's enhanced a bit, which we'll get to in a moment. And then there's a second subsection in the existing policy that insures against loss if the actual transaction vesting the title in the insured is found to be a preference under federal bankruptcy or state insolvency law. But that doesn't, in the existing policy, that doesn't include coverage resulting from the effect of a court order providing for an alternative remedy. Well, in the 21 policy, that coverage against loss resulting from a court order providing for an alternative remedy now applies to both of those subsections, both the avoidance of the prior transaction and the effect of the present transaction being determined to be a preference. And so that's certainly an improvement. There's also an improvement to that first subsection that insures against loss resulting from the avoidance of the prior transaction being found to be for example, a fraudulent transfer or fraudulent conveyance because of the effect of bankruptcy or creditors' rights laws, because there's now a subdivision of that coverage that also protects against loss or damage to the extent that that particular prior transfer is found to be voidable under the Uniform Voidable Transactions Act. And that's a new law that again has made its way into the 21 policy form. So all in all, a bit of an upgrade for covered risks involving creditors' rights. And here are the two provisions. And that's leads us into the exclusions. And as I said, we've got some changes here too. So both the owner and the loan policies have two new exclusions, which we'll get to, but there are changes to other exclusions as well, although those changes are primarily to make those particular exclusions or make the language in those exclusions consistent with the revisions appearing in the covered risks and the conditions elsewhere in the policy. For example, we talked about the change in the language to covered risk 6. Well, there's still an exclusion 1 here under the new policy. And just like under the existing policy, that exclusion addresses loss resulting from governmental regulations. And in this case also excludes loss resulting from any governmental forfeiture, police, regulatory, or national security power. Now, again, the distinction between the exclusion and the covered risk is that you recall the covered risk applies when there's an enforcement notice recorded in the land records at date of policy, whereas this exclusion would apply if, for example, nothing was recorded. There's also an update to the language in exclusion 3. Exclusion 3, excuse me, you'll recall, excuse me, updates the language that has to do with actions or inactions on the part of the insured and damage resulting from that. So, for example, one of the exclusions, well-known exclusions in 3 is matters created, suffered, or assumed by the insured, but there's also another exclusion or another subdivision of that exclusion in the existing policy that talks about an exclusion for loss that wouldn't have resulted if the insured had paid value for the property. Well, that particular provision has been or that particular standard has been tightened. Now there's no longer an exclusion for matters based on the insured's failure to pay value, as that kind of general term is used. Now the exclusion is for loss or damage that would not have been sustained if the insured had paid consideration sufficient to qualify the insured as a bona fide purchaser. And we can move on to the next provision, which I think is the covered rights exclusion. Yes. And so the covered rights exclusion, first of all, contains a clarification that the loss resulting from the transaction being or considered a preference is excluded if not given as contemporaneous exchange for new value. So again, that whole standard is tightened up a bit. The exclusion for loss resulting from the transaction being avoided is also updated to the extent that it excludes loss or damage resulting from the transaction vesting the title in the insured, being considered a voidable transfer under the Uniform Voidable Transactions Act. So this may sound very familiar to the coverage that was given in the covered risk, but it can be distinguished from that covered risk provision in the sense that, remember, the covered risk talks about coverage resulting from the voidability of a transaction when that transaction occurs prior to the one vesting the title in the insured. Whereas this exclusion addresses the situation where there is a voidability of the transaction vesting the title, that is the deed into or the mortgage creating the insured mortgage. Okay. And I think that does it for the existing exclusion. Now we move on to the new exclusions. So there's a new exclusion in both the loan policy and the owner policy for loss resulting from a Paca Pasa trust. While it's very careful to state that we're not simply taking away coverage that we just provided in the covered risk. The distinction here, again, between the exclusion and the covered risk is that, as you recall, the covered risk insures against loss or damage resulting from the enforcement of a Paca Pasa trust to the extent of the enforcement described in a recorded enforcement notice, whereas this exclusion applies to situations where that Paca Pasa trust enforcement is not reflected in any recorded document. And then we have another new exclusion, which is for loss or damage resulting from any discrepancy in the area of or acreage of either the land or the improvement on the land. And while this might initially seem like it's some sort of pullback of coverage, I think there's, based on my discussions with some claims folks, there's certainly some case law out there that finds that there's not supposed to be coverage for this sort of thing in the policy in the first place, but it's also very common to find an exception that sounds very much like this in the Schedule B of policies. So what this will do is just make it so it's no longer necessary to include that exception in the Schedule B, because it will now be built in to the exclusions of the policy. And that brings us to the changes to the schedules that I was talking about. And there are changes to both the Schedule A and the Schedule B. The Schedule A takes a page from the 2016 policy commitment and includes an optional transaction identification data section. Although, again, emphasis is on optional. It's not absolutely necessary to have it in there. And it makes it very clear that that data that's provided is informational only and is not part of the coverage under the policy. Another more useful provision that's optional enables the Schedule A to incorporate specific endorsements, either ALTA endorsements or endorsements that are proprietary to the title insurer that's issuing the policy. So that's a great addition to the Schedule A. That brings us to the changes to the Schedule B. And we have the Schedule B beginning with that language that I was referring to earlier about discriminatory covenants. Again, this is an update from the language that first appeared in the 2016 commitment, but now both the policies and the new commitment have this updated language. And the point of the language is to say that to the extent that the policy Schedule B takes an exception for, let's say, a set of restriction containing a number of different covenants, and it just so happens that one of those covenants is an illegal discriminatory covenant, as the policy defines that, then the policy will treat that discriminatory covenant as redacted and not republished, and only the, well, valid and legal restrictions will be accepted from coverage under the policy. So that's a clear direction or explanation of how those discriminatory covenants are treated and how the rest of the restrictions will be treated in the policy. And that leaves us or brings us to the other change to the Schedule B, which I think is also an important and useful change, which revises or includes this lead-in language immediately preceding the list of exceptions, where it will say this policy does not insure against loss or damage resulting from the terms and conditions of any lease or easement identified in Schedule A, as well as the following matters. So what this does is to address the situation where the property that's being insured includes a leasehold interest or together with an easement, something like that. And what it's saying is, rather than having to take a corresponding exception in the Schedule B for the terms and conditions of that lease or that easement, it's no longer necessary to do that because of this lead-in language here. So should be a time saver and a useful addition. And with that, I believe I'm done with my section, and I'm going to turn the program over to my colleague, Tucker Dulong.
Don, thanks very much for that great explanation. Thanks everybody also for being here. And thank you, Stuart, for the Vanderbilt shout out. I really appreciate that. Very dismayed last night to see that the men's basketball team fell short to the much hated Kentucky Wildcats, but fortunately baseball season is right around the corner. So we have something to look forward to there. In any event, I'm going to move on and talk about the conditions sections of the 2021 loan and owner policies. I'm going to start by taking you through some of the additions and changes to condition number 1. This is where you're going to find the definition of terms provided in both policies. We have some noteworthy and important revisions to some of the existing terms, including the definition of insured and public records. Also, some new terms have been included, including the definitions for affiliate, discriminatory covenant, enforcement notice, pocket deposit trust, etc. So we'll jump in here. I'm going to start with condition 1A in both the loan policy and the owner policy. This is where you're going to find the definition of affiliate. that new definition, and this is important because we see the term affiliate incorporated into the definition of insured, and it bears on the continuation of coverage where you have a transfer from an insured. So what is an affiliate? An affiliate is an entity that is wholly owned by the insured. It is one that wholly owns the insured. And it also covers a situation where that entity and the insured are both wholly owned by the same person or entity. We have a new definition of consumer protection law that you will see in condition 1C of the loan policy. This is sort of a condensing of two terms that were used in the 06 policy series, terms credit protection laws and truth in lending laws, which were separately defined, now fall under the umbrella of consumer protection law. It's sort of more of a catch-all type of usage here, where we're covering any law regulating trade, lending, credit, debt collection practices, any consumer financial law, any other law relating to truth in lending. The next one we'll touch on is the definition of discriminatory covenant. This is found in condition 1E of the loan policy and 1D of the owner policy. We just heard John a moment ago talk about how this is incorporated into the 2021 policy, and in particular, it is utilized in that lead-in language in Schedule B, preceding the Schedule B1 exceptions. The concepts here essentially in the event that there is some illegal discrimination based on personal characteristics such as race, color, religion, sex, sexual orientation, things of that nature. In the event that there is a exception document that is listed in Schedule B1, those such matters, those that illegally discriminate, will not be deemed to be republished simply by virtue of the fact that they are incorporated into a list of exceptions in the policy. The next definition we're going to move to is condition 1J of the loan policy. This is where you see the updated definition of insured. There's not really an alteration of coverage here, but there is some clarification that an insured is also going to be a person that holds the title after acquiring the indebtedness, regardless of how they acquired it. Additionally, in the 2021 loan policy, in the event of certain transfers from a named insured, the transferee is going to also be deemed to be an insured under the policy. In particular, the situation where the grantee is an affiliate. We just talked about what that means. And also, it's important to note that there's no longer any condition that the transfer be for no consideration. So it can be a for consideration transfer for an affiliate, and that affiliate will be deemed to be an insured under the policy. A situation where an affiliate acquires the title directly through a foreclosure or deed in lieu. Also a situation where the transferee is a government mortgage agency or instrumentality, and you see those words are all in caps. Government mortgage agency or instrumentality is also a new defined term, which we will get to in a moment. And here again, you see the provision as it actually appears in the 2021 loan policy. All right, so moving on now to the owner policy, condition 1G is where you see or will find the definition of insured in the owner policy. So again, we have situations here where a transferee from a named insured will also be deemed to be an insured under the owner policy. The first item, the bullet points in the middle of the slide, a trustee or beneficiary of a trust created by a written instrument established for estate planning purposes by the insured. That's a familiar concept. However, now in the 2021 policy, that there is no longer a requirement that any such conveyance or transfer be made for no consideration. So that's an improvement there in coverage. The two items in the second and third bullet points in the middle of the slide, those are new categories of transferees that will be considered insureds under the owner policy. A spouse who receives a title due to divorce, dissolution of marriage, also a transferee by a transfer effective at death or otherwise authorized by law. And then the third bullet point there, another insured. So a transferee who is another insured named in item 1 of Schedule A. So if you have multiple insureds named in the original policy, and then you have a transfer between named insureds, the transferee insured will receive the benefit of the title coverage that was owned by the grantor insured. And here again is a copy of the provision as it appears in the owner policy. All right, moving on now to condition 1H in the loan policy. You heard me mention a moment ago that term government mortgage agency or instrumentality. In condition 1H of the loan policy, this is where you will find that definition. And that definition you will see used cross-referenced in the definitions of insured, as we just talked about, as well as the new defined term obligor, which I'll talk about in a moment. But essentially, what are we talking about here? We're talking about an agency or instrumentality of the government that either owns the indebtedness, is an insurer, or a guarantee or guarantor. And here we move now to the definition of obligor, which we find in condition 1P of the loan policy. An obligor is simply a person or entity that is or becomes a maker, borrower, or guarantor of all or part of the indebtedness that's the security for the insured mortgage. This definition you see primarily used in the policy in the updated condition 12 regarding rights of recovery upon payment and settlement. And we will talk a little bit more about that in a minute. Okay, and so now this moves us along to condition 1R in the loan policy and 1M in the owner policy. This is where we find the definition of public records. This has been modified from the 06 policy. Efforts here essentially were to clarify and distinguish between those types of records that are intended and generally used within the context of a title insurance policy, things that bear on the title, recording and filing systems that are established for purposes of imparting instructive notice on a purchaser of real estate, and sort of separating out other types of things that might be thought of as public records, but that don't generally bear on real estate title. So we've pulled in some language here, or incorporated some new language to specifically exclude certain types of records that are not public records, if that term is defined in the policy, things such as records pertaining to environmental remediation, planning, permitting, zoning, licensing, building health, public safety, et cetera. So those now are specifically identified and excluded from the scope of public records as that term is used in the policy. So moving on now to condition 1S in the loan policy and 1N in the owner policy. This is where we find the new defined term state. And as you heard John mention during his portion of the presentation, this term is utilized in the choice of law provision that's been updated in light of the McGirt decision, but essentially a state is any state or commonwealth of the US within whose exterior boundaries the land is located, including DC, Puerto Rico, the US Virgin Islands, and Guam. So that takes us through the end of condition 1, the end of the revisions and updates to the definitions of terms. There were some of the other conditions that also were revised and updated. Condition 3, as you see here, was tightened up slightly relative to the notice of claim required to be given by an insured claimant. There was a revision in the lead-in paragraph where previously the language read the insured shall, now it reads the insured must. Also in subparagraph B, there were some changes. A rejection of the title was modified slightly to read any rejection of the title. And then in the very end of the condition, the statement relative to the situation where the company is prejudiced by failure to provide prompt notice, the liability to the insured claimant. Previously it said it shall be reduced, now it says is reduced. So just a few tweaks there to kind of tighten up that language in condition 3. In condition 8 of the owner policy and the loan policy, we see some changes as well. There's a change made to the title of this condition. The phrase contract of indemnity was added. Previously, the title of the covered risk simply said determination and extent of liability. So as you might gather, the condition clarifies that the policy is simply a contract of indemnity. Some language was pulled in. I think that mirrored some language that you see in the commitment, explaining that the title policy is not intended to be an abstract of title. It's not intended to be a report on the condition of title, a legal opinion about the quality of title, or any other representation about the status of title, and that the company is not liable for any claims alleging negligence or negligent misrepresentation in connection with the policy, and that it is simply a contract of indemnity against actual loss incurred or sustained by the insured by reason of a covered matter in the policy, and that's that. There's also some improvements in coverage, particularly with respect to the ability of the insured to select a date for determining the value of the title for purposes of calculating loss. So we'll touch on that here in more detail. So condition 8 in the loan policy. So fair market value of the title under the loan policies generally calculated using either the date that the insured acquires the title through foreclosure or deed in lieu. It can also be the date that the lien of the insured mortgage is either extinguished or rendered unenforceable by virtue of an insured matter under the policy. There's a new subsection as well that's been added to condition 8. There's some additional alternatives that are provided to an insured claimant in the event that the company attempts to cure the title and is unsuccessful in doing so. First off, the amount of insurance will be increased automatically by 15%. And also, in that event, the claimant can elect to either use the date that the curative action was either settled or otherwise concluded, or the date that the insured's notice of claim was received by the company as the date for calculating fair market value of the title. So some improvements there and additional alternatives provided for the insureds there. And here is the provision as it appears in the loan policy. In the owner policy, determining fair market value, the title is generally calculated using the date that the insured discovers the defect. However, now in the event that at the date of policy, the title is rendered void by reason of a matter covered under the policy, then the claimant can send written notice to the company and elect to use the date of policy as the date for calculating fair market value instead of the date of discovery of the defect. Similar to with the changes to the condition 8 of the loan policy, if the insurer does pursue its rights to cure and is unsuccessful, first off, the amount of insurance is going to increase. Previously in the 06 policy, the amount of that increase was 10%. That has been improved. It is now moved up to 15%. And also the insured claimant can elect to use either the date of settlement or conclusion of the curative action as a date for determining value of the title, or the date that the company received their notice of claim. Condition 10 in the loan policy is now entitled a reduction or termination of insurance, and there's some improved coverage here for the insured lender by the inclusion of a new subsection B, which states that in the event that the title is acquired by the insured through foreclosure or deed in lieu, any credit that occurs there against the amount of the indebtedness is not going to reduce the amount of insurance. Paragraph 12, this is the recovery and subrogation rights provision. The primary change here, as I mentioned earlier, there is a new defined term, obligor. The deck has sort of been shuffled here to incorporate that term into the condition, but substantively, there's not much of a change here. Conditions 15 in the loan policy and 16 in the owner policy. The 2021 policies contain the updated choice of law provisions that John had mentioned in response to the McGirt decision, and essentially, we just have a new reference to the fact that federal law will apply as applicable to the extent it controls in the event that state law does not. And these are the choice of law and form provisions as they appear in both policies. All right, that brings us close to the end now. Conditions 17 in the loan policy and 18 in the owner policy. This is the class action provision. Any claims and disputes must be brought in an individual capacity and cannot be brought as a class action. Likewise, with the arbitration provisions, claims and disputes cannot be have to be brought in individual capacity. Also, as far as arbitration goes, if the amount of insurance is $2 million or less, any claim or dispute can be submitted to binding arbitration at the election of either the company or the insured. Where the amount of insurance is greater than $2 million, there has to be an agreement by the company and the insured to submit the matter to arbitration. And any arbitration is going to be conducted pursuant to ALTA arbitration rules. And here is that arbitration provision for your reading pleasure. Okay, so that brings us through to the end of the changes to the standard owner and loan policy. Of course, many other forms were reviewed and tweaked, and we don't have time to go through all of those today, but just for your information, the commitment forms were updated, short form residential loan policy was updated, the homeowners policy and expanded coverage loan policies were updated. Dozens of endorsements were updated, mostly to provide a dovetailing with the 2021 policy changes, the zoning endorsement series, the 4s, the 10s, all the way through up into the 30 series, construction loan endorsements. All of these things were updated to maintain continuity with the 2021 forms. There were some new endorsements as well that were created. The so-called Flex Mod endorsement, the residential loan modification endorsement was created. So there really was a lot of work that went into this. And I meant to ask John earlier during his part of the presentation a question that I know the answer to. But how long did this process take from start to finish? When did it really kick off? Considering that we had 06 was the last policy iteration.
My recollection was that we first started talking about revising the standard policy forms back in 2012. So
Yeah.
it's quite a while.
10-year process. 10-year process.
Yeah.
So a tremendous amount of work went into all of this. So John, how can folks watching this prepare?
Well, of course, as they see up on the slide here, training and guidance, this is certainly a good first step. There's a need to provide for updates of software, and speaking as a company that's involved in revising these forms, we're in the process of doing just that. We will be sending out bulletins. I'm sure other title insurance companies will be sending out bulletins and offering webinars. The ALTA started off this process by developing a webinar similar to this one, and then a group of the forms committee, which included me, did put together this particular program, this webinar, which can really be used by any of the members of the ALTA. So this is certainly something that shows you how the ALTA itself is a great resource, and you can get a lot of information off of the website of the ALTA, or simply contacting the ALTA if you're a member.
John, this is Stuart. A good question that came up was, have these forms been officially adopted? Or what is the next step if there is one?
Yes, the forms have been officially adopted by the ALTA, and then as I said, it's up to the individual companies to decide whether or not they'll adopt them. Although when it comes to something like the basic policy forms and a lot of other of these forms that Tucker has identified, it's a foregone conclusion that to the extent that their regulatory environment allows them to adopt these forms, the other companies will be adopting them. And then it's a matter of changing their systems to accommodate these forms, and as I said, updating the software. There's also a regulatory component to it, in that you need to file these revisions and these new forms with the various states where filing is required.
So there is a transition period with each company, each state, where it might be the older version, might be the newer version.
Yes, absolutely. Yes, the actual, there's a reference to the term decertification when the old form is sort of phased out. And the decertification date that has been mentioned for the 2006 forms is not until I believe, the end of this year. So there's a pretty long transition period.
Okay, I do want, just real quick, I want to just say that when I introduced you both, my computer went out. I don't want to do you both a disservice. So let me just say again for everyone who's listening, that Jonathan Anderson and Tucker DeLong both work with CADIC, which is Connecticut Attorneys Title Insurance Company. John, I think you're based in Connecticut itself, right? Hartford or somewhere?
I am. I'm based at the headquarters in Rocky Hill. Yes.
Okay. And then Tucker is a Massachusetts State Counsel. He's admitted to the bar in Massachusetts, Maine, and New Hampshire. So up there in the Northeast.
Yeah,
there's
I sit
another.
in Waltham, Mass, just outside of Boston.
Okay.
And I
there's
just,
one.
oh, go ahead. I'm sorry, Stuart.
I'll say there was a question, but go ahead and add what you were going to you were thinking about.
I was just going to say we do have a branch office in the great state of Georgia, so we're very happy to be there.
All right. And one more question was, do the 2021 ALTA form revisions apply equally to homeowner and short form policies?
Well, yes, they do. I mean, there are changes to both of those policy forms that, as Tucker mentioned, represent efforts to make those forms consistent with the changes that were in the basic policy form. So the homeowners policy has been upgraded to include some of the terms and provisions that we saw in the standard policy forms. That revised form, that updated homeowners policy form, can be found on the ALTA website for anyone who wants to look at it. I believe that's in the public section of that particular website. So it's not necessary to be a member or to log into the ALTA in order to see that new form. And there's not only an example of the new form and the old form, but there's a red line version which shows you the changes between the old form and the new form.
Okay. So we're just past 12 o'clock, and I'm having some computer problems this morning. So some people might start logging off, but we can stay on for a few minutes in case there's more questions that pop up. I do want to say that the third and final session is Thursday, February 17th, from 10 to 12 p.m., 10 a.m. to 12 p.m. The first session discusses e-notes and foreclosure e-notes. The second session is with Ali Jett, quiet title action process and substance for that. So we are past 12 o'clock and people might be dropping off, but we can just wait another minute or two if you guys are okay to see if any other questions get posted. And thank you to you both for preparing this and working with the Forms Committee and presenting this morning. And thank you, I think he's dropped off as well, but Chad Hunt from the first session, that was very helpful as well. And then I will go back and look for the material that, if we haven't circulated the material that was sent to us by Chad Hunt, well, I'll send that to Lane and he can send it off as well. And just as a reminder, Lane with the State Bar will be forwarding CLE credit to the State Bar, so nothing that anyone has to do to get the credit for the hours, which I guess March 31st is the deadline for last year. So today would count for last year as well. But anything else, Tucker or John, that you'd like to mention before we wrap it up?
No.
I don't think so. So we don't have any additional questions?
Doesn't look
No.
like it.
Okay, all righty.
Well, thank you both for calling in from out of state. We appreciate it. It's one of the benefits. You know, we actually like the in-person event, but a benefit of having this webinar virtually is people can call in and present from out of Georgia. So thank you. And that is it for now. And we'll follow up everybody in 2 weeks. Thanks again. Have a good day.
Perfect.
Thank
Thanks,
you.
Stuart. Take care,
This
everybody.
concludes today's webinar. Thank you for joining and have a great day.